Yeah, yes, done.
Namaste and pranam to 900 of you who have joined from across the country. Uh, in Anand Kumar Pratishthan, we take great pride and it brings us so much joy to know that we are able to have a dialogue with a student who is sitting in Chikkodi Law College, to a professor who is sitting in Delhi University. We have students joining from NLU Ranchi, literally from across the country. Thanks to this medium, this online medium that we have today, we have people joining today. Thank you and welcome to all. I would like to firstly introduce Anand Kumar Pratisthana itself. Anand Kumar Pratisthana was started on the passing away of the sad demise of Anand Kumar ji. Anand Kumar ji, all of us know, he was a member of parliament for 2 decades. He was a minister holding over 10 posts, one of the youngest cabinet ministers in Atalji's government. He had many firsts. But something that many might not know about him is that he was a lawyer. He was a person who truly believed in civil liberties. It so happens that his public life started with a writ petition that had to be filed because he was put in jail during emergency and he was not allowed to write his second PUC exam. So civil liberties and ensuring that everybody has civil liberties to the fullest was something which was very close to his heart. With his guidance and with his inspiration in mind, Anand Kumar Pratisthana was started. Today, the founding trustee of Anand Kumar Pratisthana, Shri Tejaswini Anand Kumar ji, is also with us. I would now like to invite her to give us a brief about what Anand Kumar Pratisthana is doing and what is Nation First Dialogue. Tejaswini Anand Kumar ji, she was a scientist with the Aeronautical Development Agency. She worked on the light combat aircraft. Thereafter, she took retirement and she started her social work stint and by starting Adamya Chetana. Adamya Chetana, it has grown over the past 20 years. It feeds over 1 lakh midday meal children. It's doing wonderful work. I would now like to invite Tejaswini Anand Kumar ji to sort of tell us about today's event and about Anand Kumar Pratishthan.
Namaste. Thank you, Aishwarya. Respected Professor P.V. Krishnapaji, who is the President, Chairperson of Anand Kumar Pratishthan, all the dignitaries who have assembled. As we all know, our country, India, became Swatantra Bharat after a long struggle of thousands and thousands, with a promise that each child of our nation will get equal opportunity and no discrimination. But today, after 76 years, we say we are all equal, but we know some are more equal, and it may be in inheritance, in marital age, adoption, or custody of minor child, giving financial support, and so many areas we see this particular thing. So it is actually today under the leadership of our beloved Prime Minister Shri Narendra Modi ji, we are able to see the light of that equality uniform civil code. And to have an open dialogue and to understand in depth about this issue, Anand Kumar Pratishthan has organized this Nation First Dialogue, which is 12th program in the series on uniform civil code, ground reality, beyond the noise. And with great pride, I welcome Justice Shri N. Kumar ji, who is not only a highly respected judge of Karnataka High Court, but also a legal luminary who has, through his work and especially his judgments, judgments have strengthened women's rights and create a judicial precedence of taking into consideration the last man standing, the Antyodaya. And of course, the principle of Deen Dayal Upadhyayji's Antyodaya, that Anand Kumar ji always followed, and of course this concern has led to founding of our organization Adamya Chetana, which we founded in 1997, and today we are serving midday meal to around 1.5 lakh children from Bangalore, Hubli, Kalburgi in Karnataka, and Jodhpur in Rajasthan, along with its other projects like promoting zero garbage kitchen or fossil free fuel and wall magazine, and other projects mainly reaching out to the underprivileged children and women of the society. And today we also have Dr. Anand Ranganathan today with us, a scientist and political analyst. His view on our nation's history and the current political issues of India is seen and followed with great interest by thousands and thousands. I'm very happy he has agreed to join us for this Nation First Dialogue. And also today we have with us as another speaker who is a senior advocate, Srimati Lakshmy Iyengar, one of the 5 women female designated senior advocates of Karnataka. She has created a niche for herself as a very capable, sharp, and articulate senior lawyer of her times. I'm happy to have her. I'm happy to have her today with us. And also I welcome all the students, practicing lawyers, engineers, social workers, every Bharatiya who has joined today. We have more than 1,000 registrations, and also many are watching this program through YouTube. Anand Kumar Pratishthan, which was founded in the year 2020, mid COVID period, in memory and to continue some of the works of Anand Kumar ji forward, some of his take forward his thoughts, his life. We have focused on mainly on leadership development on public policy, focusing mainly on youth and rural women. In this direction, we started a program called Grama Chetana, an initiative to equip grassroots level women, especially the elected women panchayat leaders with leadership qualities, and help them to actively join in nation building. And another program of Anand Kumar Pratishthan is the Nation First Dialogue, which is an attempt to bring together experts and policymakers to have an open dialogue on important questions faced by the society. To many senior politicians, policymakers, subject experts have joined us in our earlier Nation First Dialogues, namely Dr. Harshavardhan, Dr. Ashok Narayan, Padma Shri, Dr. Manjunath, Padma Shri, Dr. Devi Shetty were the main speakers for our first Nation First Dialogue, which is the leadership in pandemic, which happened in August 2020. Dr. Ullas Karant, a well-known ecologist, spoke on balancing development and ecology. We have Dr. Rajat Moona, who has spoke on artificial intelligence in public life. Then we had great speakers to talk on Indian pharma sector and opportunities and readiness. We had V. Muralidharan, our Minister of External Affairs, MOS on External Affairs. Many, and Dr. Abhay Karandikar spoke on 5G opportunities, and then we had Raju Chandrasekhar. So it's quite a many senior politicians and policymakers have participated in previous Nation First Dialogues, and today's is again another exciting topic. I welcome Dr. H.S. Nagraj, one of the very senior professors, founder of Prayoga, is there with us. I also welcome Dr. Mallikarjun, principal of KLE Law College, and many of his students and faculty members have joined us today. Dr. Anjan Reddy, who is the principal of RV Law College. And also we have one very senior women activist. We always regarded as our teacher, our mentor, Srimati Nirmala Tai Apte from Mumbai. And she heads the Bharatiya Stri Shakti and she's the founder of Bharti Stri Shakti. I welcome Madam Nirmala Tai Apte. I welcome all the dignitaries, all the Anandkumar Pratishthan active members again for this NFD, and I request Aishwarya to take the program forward. Thank you.
Thank you, Tejaswini ji. As usual, thank you for standing as an anchor for not just this event, but for the whole Pratisthana, for the whole trust. We also have another trustee with us today, Professor P.V. Krishna Bhattji. Sir, welcome, sir. Our first speaker today is Dr. Anand Ranganathan ji. Dr. Anand Ranganathan ji, if you permit me to say so, is a scientist by day and a political scientist by night, with a deep interest in finding a cure to malaria and tuberculosis. Clearly, a person with who has concern for the health of the nation. I wanted to ask you, sir, in regard to the Uniform Civil Code, we know that our country is presently standing, it's poised to become the Vishwaguru, poised to be known in the next 10 years as a developed country. In such a situation, how important is it to have a policy framework, to have a regulation and a law which helps its citizens in evolving, which takes care of the mental and physical health of every girl child, of every woman who is today unable to get inheritance? There are many communities, as we all know, who still practice child marriage and which is allowed by law. Then such is our situation. How important is Uniform Civil Code? And how could it really push our nation into becoming a Vishwaguru? Over to you, sir.
Yeah. Thank you very much to the organizers, the Yashwini ji, Aishwarya ji, and all the exalted fellow panelists and speakers. It's a real pleasure and an honor to be part of this very important discussion. It really is a heartfelt thanks. For two reasons. One is that I am also a teacher, and I firmly believe that in domains where I do not have an expertise, well, I don't have an expertise in every domain, including science, but I've always believed that a teacher who stops being a student then stops being a teacher. And I think, as Aishwarya ji mentioned, away from 9 to 5, which is my science life, I delve into politics. But can I clarify that I've always believed that one should never mix politics with science, because then all you end up with is political science. But having said that, I think some issues transcend experts, expertise, and domains. And these issues are the ones that actually form the core of the country, the nation going forward. They might not address, they might not seek an apology or retribution or reconciliation for the crimes that have been committed in the past. But a nation has to look forward. A nation has to look towards the future. A nation that might not have cared for our past generations has to care for our future generations. And for that, Aishwarya ji, I think one of the most important resolutions one could bring about or policy changes would be the Uniform Civil Code. I firmly believe it's not just a necessity for India. I think it's a prerequisite for not only India as it stands today, but also for India's unity. Because religious fanatics may have held to ransom a generation previous to ours through partition. They may have held to ransom our generation through Shah Bano, as we all know. But we must not, and I dare say we will not, allow them to hold to ransom our future generation. Very simply, one sentence, we have to say no no to religious fanatics, because enough is enough. So I just broadly want to touch on 4 issues, and then if time permits, after those 4 issues on which I deliberate very briefly, I would like to quote verbatim what people said during the Constitutional Assembly debates, because one must not, especially in issues as important as the Uniform Civil Code, I believe, deviate away from the facts, because then it becomes a domain of opinion making, and everyone has an opinion, but there are only set facts on which one must base one's opinion. So these are the 4 issues on which I have formed my opinions. And of course, these are based on facts and logic. So the first one is this pretext that people, the naysayers of UCC, always give, which is that we have to have diversity. India is a land of multiple religions, people who are diverse, cultures that are diverse. So we have to respect that. I'm sorry. On the pretext of diversity, one cannot allow discrimination to flourish. And that is what has been happening. Let me give you just one example, and then it would make things very clear. Supreme Court very recently, last year, or maybe I think this January, it conferred Hindu daughters with equal rights to father's property, going back to 1949. And it said, and I quote, Hindu texts recognize female rights, unquote. This is what the Supreme Court said. But in India, the same country that has the same Supreme Court, because of the Quranic verse 411, a Muslim daughter is entitled to only half of what a son is. I wonder, does this not bother our activists and those who are fighting for women's rights? What happens to all their speeches about equality and feminism and ending not just Brahminical patriarchy, but patriarchy? Cat gets their tongue when you quote this verse. Do they not have any sense of morality or ethics when it comes to discussing Muslim women's rights? Is this not discrimination? For how long will you make Muslim women suffer discrimination by shrouding them in this burqa of diversity? Just because you have a diverse culture or a religion that is different, or a law that is consecrated in that religion, a dogma, on the pretext of diversity, you would allow any discrimination to prosper? That's point number 1, which is that in the garb of diversity, or on the pretext of diversity, you must not allow discrimination to flourish. Point number 2, and this is where logic comes in. There already is a sort of uniform civil code that is, or that has been applicable in Goa for decades. In fact, it's been there ever since we can remember, ever since the formation of Goa itself. And Goa has a minority population, Hindu, Muslims and Christians and non-Hindus, totaling 38%. 38% of Goa are minorities. So you tell me, are the minorities in Goa suffering, or are they being discriminated against because of the Uniform Civil Code? If they are, I haven't heard. On the contrary, the Goanese are very happy. So when the UCC, a sort of UCC that I have a lot of issues with, by the way, because I've read the UCC that is applicable in Goa, and it is heavily derived from what the Portuguese thought should be the Uniform Civil Code. And I think it's quite discriminatory in many aspects, but still it's in place. And Goanese don't seem to have any issue with that. So the point number 2, the logic, point number 1 was that the naysayers were saying that we must have diversity. I have addressed that. Point number 2, the naysayers were saying that people would be unhappy if the UCC comes. I have addressed that. Point number 3 is that the Uniform Civil Code is enshrined in our constitution under the directive principles. It is part of our constitution. So when you say Constitution as a book is more important to me than any religious book, some say, then why are you being a naysayer there when you already have the UCC as part of the Constitution? And clause A of this point number 3 is that none other than Dr. Ambedkar was a proponent of it. In fact, he rejected amendments of exceptionality that were proposed by Muslim legislators to Article 35, which is now Article 44, Directive Principles, that asks for the UCC to be implemented. Quote, I personally do not understand why religion should be given this vast, expansive jurisdiction as to cover the whole of life and to prevent the legislature from encroaching upon that field. After all, what are we having this liberty for? We are having this liberty in order to reform our social system, which is so full of inequities, discriminations, and other things, which conflict with our fundamental rights. Unquote. This is Dr. Ambedkar. Besides, the UCC has been ordered to be implemented on more than one occasion by the courts themselves, most famously in the Shah Bano case. Quote, a common civil code will help the cause of national integration by removing disparate loyalties to laws which have conflicting ideologies, unquote. So, Ambedkar ki nahi sunni, Supreme Court ki nahi sunni, Constitution ki nahi sunni, kiski sunni hai? Sharia ki. And by the way, for bringing in social reforms and equality to Hindu society, the same Congress gladly brought in the Hindu Code Bill, but it cowered away like a, as I say, wet cat when it came to reforming Muslim society. Why? I repeat, I am against any law or code that discriminates between gender, sex, caste, creed, religious denomination, communities, or groups. Finally, on point number 4, and this is very dear to me, because I firmly believe that above everything, there is a pursuit of a law or a code that begets what I call universal good. By universal good, I mean that I want a law that is just, equal, and based on science. Because to be honest, only then can societies progress. And I'm not saying anything new because we've seen this time and again. Let's take a couple of examples. The abortion limit has been decided, has it not, by science? And it has changed over years. Right now, it is, I think, 22 weeks. It wasn't that to begin with. Now, I ask you, was this scientific intervention, call it scientific medical, was that not warranted? Similarly is the case with infant vaccination, contraception, which is prohibited in many societies. Was that not warranted? I ask you, in many societies that prohibit vaccination, what do you want? You want your children to die or to be afflicted with polio just because in the name of diversity, you want the constitutional article that says you are free to actually, accept the tenets of your religion and to follow your religion. You have a constitutional right. Do you have a constitutional right to kill babies or to make them suffer or to make them disabled for the rest of their lives just because of this diversity? Is it because of this diversity that you would not allow your child to get vaccinated against horrendous diseases, including polio? So is scientific intervention having this uniform law of, it is in fact called universal vaccination, was that not warranted? Similarly, science tells us that marriage of a woman upon puberty, which is sanctioned in Islam, which is demanded by the All India Muslim Personal Law Board, which is ratified by the Indian courts as recently as a couple of years ago by the Gujarat High Court. Incidentally, the judge that ratified it is now in the Supreme Court. I don't want to say more because there already is a contempt case against me, but luckily we have an exalted honorable judge as one of our audience, so maybe he would help me out. But the fact of the matter is that if we have a child marriage or the marriage of a woman that is religiously sanctioned upon puberty, it causes irreversible physical and mental damage to the woman's body. Science has told us this. Medicine has told us this. Scientific research has told us this. But should we continue to cause this irreversible physical and mental damage to a child or a woman in the name of diversity? You want to continue to marry girl childs because your community has been doing so, while every other community in India has to follow the Prohibition of Child Marriage Act? I ask again, the feminists and other people who fight for women's rights, is this pro-woman? So as I said, the Universal Civil Code will eradicate discrimination. It will unify us. It will not divide us. And its time has come. Finally, just a minute, I want to delve on the debates that happened on, in fact, precisely 23rd November 1948. There was a very robust debate on the exact framing of the article of our Constitution concerning the Uniform Civil Code. And this happened on 23rd November 1948. It's a debate that included luminaries such as Dr. B.R. Ambedkar and Dr. K.M. Munshi, among others. When the Muslim members of the assembly proposed that the Civil Code article that simply stated, quote, "The state shall endeavor to secure its citizen a uniform civil code throughout the territory of India," unquote. When they said it was tyrannical to the minorities and an example of the majority riding roughshod over the rights of the minorities, and that it should have a clause mentioning that the Uniform Civil Code would be applicable to every Indian, with the exception of those who are following their personal laws. That is, quote, "provided that nothing in this article shall affect the personal law of the citizen," unquote. Mr. Munshi had this to say: "A further argument has been advanced that the enactment of a civil code would be tyrannical to the minorities. Is it tyrannical? Nowhere in advanced Muslim countries the personal law of each minority has been recognized as so sacrosanct as to prevent the enactment of a civil code. Take, for instance, Turkey or Egypt. No minority in these countries is permitted to have such rights. But I go further. When the Shariat Act was passed on, when certain laws were passed in the central legislature in the old regime, the Khojas and the Kachi Memons were highly dissatisfied. They then followed certain Hindu customs for generations. Since they became converts, they had done so. They did not want to conform to the Shariat. And yet, by a legislation of the central legislature, some Muslim members who felt that Shariat law should be enforced upon the whole community carried their point. The Khojas and the Kachi Memons most unwillingly had to submit to it. Where were the rights of the minority then? When you want to consolidate a community, you have to take into consideration the benefit which may accrue to the whole community and not to the customs or a part of it. It is not therefore correct to say that such an act is tyranny of the majority. If you will look at the countries in Europe which have a civil code, everyone who goes there from any part of the world and every minority has to submit to that civil code. It is not felt to be tyrannical to the minority. The point, however, is this: whether we are going to consolidate and unify our personal law in such a way that the way of life of the whole country may in course of time be unified and secular. We want to divorce religion from personal law, from what may be called social relations, or from the rights of parties as regards inheritance or succession. What have these things got to do with religion? I really fail to understand. Take, for instance, the Hindu law draft, which is before the Legislative Assembly. If one looks at Manu and Yajnavalkya and the rest of them, I think most of the provisions of the new bill will run counter to their injunctions. But after all, we are an advancing society. We are in a stage where we must unify and consolidate the nation by every means without interfering with religious practices. If, however, the religious practices in the past have been so construed as to cover the whole field of life, we have reached a point where we must put our foot down and say that these matters are not religion, they are purely matters for secular legislation. This is what happened almost 75 years ago. And we think we are advanced now. Look at the enormity of the situations that were being tackled right after we had got partitioned. This is the kind of openness with which things were being discussed, where you were not just thinking of a particular community or a particular sect within that community. You were thinking of unifying the country. And here we believe that in the garb of diversity, we bring in discrimination. We follow the laws that discriminate within people of that community. And we believe we are advancing towards a future that is progressive. I'm sorry. It is not progressive. It is regressive. Thank you very much. I shall end there. Thank you.
Thank you, Anandji.
Thank you so much.
What we derive from your talk is that there is a lack of political courage. And this government has shown at least an interest to have UCC, and that is commendable. Your point on the fact that you said, can diversity justify inhuman violence? As in something that all our students, everybody who's here can ponder upon. As in that's a very, very strong statement, that an argument that I think we should all seriously sort of consider. Thank you very much, Anand Ranganathanji. We understand that you are in between a G20 debate, a live stream that is happening. But thank you for taking out the time and joining us and sharing your views on this issue. Thank you very much.
Thank you very much. Most kind. Thank you so much.
Anand Ranganathanji also spoke about Brahminical patriarchy and how patriarchy has been shown to be Brahminical in nature. As in, just the coining of this word is so unfortunate. But what is patriarchy really? Our next speaker today is Senior Advocate Lakshmy Iyengar. She is an athlete by heart, a sportswoman truly. She actually represented Karnataka state in cricket. She is the national champion of go-karting. But beyond that, she's an athlete, but she's also a lawyer with 25 years of solid practice. As young lawyers, all us women young lawyers in the Karnataka High Court, we look up to her. We sort of copy her style. I think we have great pride and with great joy that she's joined us today. Lakshmi ji, I don't want to box you into that issue of please tell us about women's rights and child rights and how UCC will bring out a phenomenal change for women across the country, which is urgently needed. You, of course, have handled matters from constitutional to corporate law to criminal law matters, and you have a very wide understanding of our present legal system. So I want to sort of allow this sort of platform for you to guide us through how we should understand UCC, and how when a friend of ours comes up to us and says why we should not have UCC, what should our arguments be to them, and why should we, to have a developed nation, fight for UCC.
Thank you so much for having me here. I'm boxed between two luminaries here, and Dr. Ranganathan has thrown in a lot of light. I think I'll restrict myself briefly to the background of the UCC, coming on to judgments of the Supreme Courts, which have kind of tried to bridge the gap, and end it with what the directive principles have brought in by way of changes, and how the directive principles have found their way into the fundamental rights, and end it with what we could probably do in future. Let's start with the background. The Uniform Civil Code was always meant to be there. It was supposed to be there, the fundamental rights. But during the debates in 1948, I think along with Munshi ji, who is ultimately a Hindu, We also had Minnu Masani, who's a Parsi. We had Rajkumari Kaur, who was initially a Sikh converted to Christianity. Now, all of these people were very much for the Uniform Civil Code because they thought that if we as a country would have to go along in terms of equality and have a kind of a bridge where there's an equal status for everybody, we would need the UCC. There was a huge uproar. Who were the ones who were against it? Now, that would be critical. We had 5 Muslim members, led, of course, by Ismail Khan. All of them were against it. This would have been very different had we had women at that point of time during the drafting of the constitution itself. And had we had Muslim women at that point of time, I don't think it would have been shunted out to the directive principles. Pandit Jawaharlal Nehru, the Indian National Congress, all of them were for the UCC. So to have a different thought process at this point of time, I don't understand why. In fact, they fought very hard to have the UCC. What happened with Dr. Ambedkar was that despite the fact that he tried to push the UCC, he realized that it was a little too early, probably because of the effects of partition and their unwillingness to cooperate. What the Muslim members felt was that they had their own personal laws, and therefore there should be no kind of changes for them because they were quite happy with what there was. Whether they were happy or not, ultimately, if we had women at that point of time to determine it, it would have been different. It wasn't. So what Dr. Ambedkar did was, all right, let's have it in the directive principles. Let's have it in part 4. And let's leave it for the subsequent generations to come. Maybe, India would have progressed by then and it would become a little more easier. And therefore, he felt that let it be decided and kept it under Article 44. Therefore, 44 said that in time to come, the governments could always at that point of time determine and bring in and make efforts to see to it that the Uniform Civil Code would be put in place. Unfortunately, even in 2023, we are still debating. You could ask why now? The issue is continuously the Supreme Courts have been trying to fill in the void. There have been so many instances. It is not about Hindus. It's not about Muslims. This is not about vote bank politics. It's been continuously tried to, they've tried to portray it that this UCC would be completely anti-Muslim, and that is not the case. The reason being, there have been several laws, whether it's Hindu society, Christianity, or Islam. There has always been some kind of disparity when it comes to women. This has been rectified by the Supreme Court by way of several judgments. Despite that, until and unless we have a uniform civil code, it would not be possible for us to move forward. We ultimately are a nation that we're looking at being one of the largest economic, we've had one of the best economic growths. We're going to be a nation where we've shown development in science, technology. Why can't we show development in the field of law by having a uniform civil code? The reason is that several of them have been led to believe that it would be anti-Islam. How would it be is the question that we have always put forth and we have never found answers. Reason being, if it comes to marriage or it comes to succession, it comes to inheritance, it comes to guardianship, it comes to custody, it comes to adoption, all of this, where is one affected is what one needs to see. And who is affected? Is the Muslim man affected or is the Muslim woman affected? In Hindus, is the Hindu man affected or is the Hindu woman affected? All along, it's been the women who have been ultimately sidelined. And therefore, there's always been an attempt to bridge this gap. We've had people like Raja Ram Mohan Roy, who's always fought for equality of women. The sati practice, we could not have eliminated it. There was a lot of, a fight over why it should be taken out. Women, in fact, said that it is our right. It's up to us if we want to step into the pyre, all of that. we had to have strict laws in place for us to eliminate the discrimination. And therefore, you cannot say that there are certain sects of society do not want some kind of progress, and therefore we will leave it to them to decide. That's not how we go about it. Now, coming to Supreme Court judgments. In Seema versus Ashwini Kumar, the Supreme Court had said that all marriages would have to be registered. This judgment was, of course, to ensure that there was no child marriage. And upon registration of a marriage, then you'd at least come to know about the age of a child. But it had far-reaching consequences beyond child marriage. What happened was that irrespective of whether you're Hindu, Christian, or Muslim, you would still have to go and get your marriage registered under the Special Marriage Act. Then what happens is that there itself is a sense of equality in place. And that made a huge difference for several women who ultimately could not go about to prove that they were in fact married. We had a case called John Vallumathan. In that, the Supreme Court had expressed its regret that under 44, there was a premise that there would be no connection between religion and personal law in a civilized society. This was, of course, with respect to Indian Succession Act. Christian women faced a lot of difficulty. And therefore, the courts felt that it was about time. This was in the year 2003. The courts felt that when there is Article 44, what is the government doing? So they wanted some kind of law in place where succession also would be uniform. We had a case of Vinita Sharma in 2022, very recently. It was with respect to the share in ancestral property, co-partnership rights. Now, what the Supreme Court did was it interpreted Section 6 and it said that it was retrospective in nature. This brought about a transformation, which Dr. Ranganathan was mentioning, because then women ended up having equal rights, half the share in all of the properties, which was not there earlier. Supreme Court again had to step in Nakara's case, where they said equal pay for equal work. This was not there earlier. Women were paid far lesser than men were in terms of even labor, manual labor. And that was brought about by sense of equality there. And most importantly, we'll have to go into two cases, which is Sharia Banu's case and Shah Banu's case, which brought about a transformation. What happened was in Sharia Banu's case, which was in 2017, the triple talaq issue was decided. While deciding the triple talaq issue, which was the talaq-e-bidat, the Supreme Court did not delve into the aspect of polygamy. It did not also delve into the aspect of nikah halala, which was ultimately put forth and left to the legislature. And the court said that let the legislator determine that. But they went on the issue of triple talaq and said that it is not part of essential religious practice and went on to say that it's illegal. That brought about a transformation for women who were left in the lurch all along. And it was not just one woman fighting. It was the Muslim Women's Board, which came along with Sharia Banu in this matter to fight for women's rights. In the Shah Banu case, which was as early as 1985, which was so important, what would women do if they were left and there was nothing to fend for themselves? They did not have the education to get themselves a job. Then the Supreme Court stepped in by way of bringing in maintenance for them under the criminal law. They said under Section 125 of CRPC, you could go ahead and claim a maintenance. Now, this brought about a remarkable change wherein it was not just for women and not just for Muslim women. It was whether it was a daughter, whether it was a mother, any of them who were left in the lurch, they could move under Section 125. So Supreme Court has all along tried to interpret sections or give a direction to the legislator to bring about some kind of change. This, of course, would not be with respect to UCC, but if you look at the Vishaka matter, where for the POSH Act to come into force, first there were guidelines framed by the Supreme Court, which then brought about the POSH Act. Therefore, at every point of time, you can't keep expecting the courts to step in and bring about some kind of guidelines for you. They keep reminding the legislature that it's about time you need to. The Shah Banu case in 1985, the relevant portion would have to be read, because the Supreme Court has very clearly said that it is time that you bring in the UCC. It is not this government trying to bring it. It's the Supreme Court who's continuously reminding the government that it's about time. In the Shah Banu case, they said it's a matter of deep regret that some of the interveners who supported the appellant took up an extreme position by displaying an unwarranted zeal to defeat the right of maintenance of women who are unable to maintain themselves. They also went on to say that it's a matter of regret that Article 44 of our Constitution has remained a dead letter. It provides that the state shall endeavor to secure for citizens a uniform civil code. And basically, the courts also had to say that a common civil code will help the cause of national integration by removing disparities. Now, the courts have clearly said this in several judgments. The courts has also said in the case of Sarla Mudgal, which was extremely important in the year 1995, it was with respect to very conveniently changing religion, converting just to marry again. And therefore, the courts in that matter in 1995 said that you need to bring about some kind of change. They also quoted stating the state shall endeavor to secure. They quoted 44. And they also went on to state that we therefore request the government of India through the Prime Minister of the country to have a fresh look at Article 44 and secure for the citizens a uniform civil code. They also directed the government of India to the Ministry of Law to file an affidavit of a responsible officer indicating the steps taken to make those efforts. So continuously you have reminders by the Supreme Court, and this doesn't seem to happen. In fact, several questions have been posed. It is not just about Muslim women, it's not just about Hindu women. What about the tribals? Well, about the tribals, the scheduled tribes have always followed, some of them have followed Christianity, some of them have followed Hinduism. It was ultimately under whichever act they came in, they were given some kind of relief. But in Jordan Denga, what happened was this was against a matter in 1985, wherein it was under the Indian Divorce Act, wherein there was no scope for either mutual consent or there was no scope for, some kind of irretrievable breakdown of marriage. So where do you go? And in that matter, the Supreme Court said that they're disappointed. They said ultimately our founding fathers had put in place Article 44. And they said that nobody seems to have implemented it till date and no action has been taken. Reason being, all of these people were left in the lurch and the Supreme Court had always had to mend, bend, and make some kind of a route for these people and find some kind of a solution for them. And so they have had to constantly remind the court. If we come as in the later judgments, in the year 2019, in Jose Paulo Coutinho's case, in fact, the court had also said that you have to come in and put something in place wherein the Article 44 is followed all through India. In Ashwini Upadhyay's case, which is very recently, a few months ago, he had moved the court stating that let there be implementation of the Uniform Civil Code. At this point of time, the Supreme Court refused to entertain the petition. The Supreme Court said that the Parliament alone can effectuate this. So what the Supreme Court said was, of course, our government at this point of time has always said that we are for UCC, but it is not for the courts to intervene. That is absolutely right. The courts could not probably intervene, but the courts have constantly reminded the legislator that it is about time and it is not being done. With all of these judgments, you get an idea as to what the Supreme Court has wanted and what all of the women in society have demanded. None of this have ever been put in place. When we come also to, there have been several questions asked with respect to how would you go about this? I would only have to say that under Article 44, it says that the state shall endeavor to secure UCC through throughout India. How do you then bring about this? Then it is under Article 368. It is the power of the Parliament to amend the Constitution. Now, if the Parliament amends the Constitution under Article 31C, all of those directive principles that have made their way, there is a provision for saving of such laws. The Uniform Civil Code, ultimately, a lot of us think that it is just going to be one code. This is like the CPC, that is our Civil Procedure Code. There's a huge difference. It is not a procedural code. This could be several codes, several laws put in place, whether it's with respect to property, marriage, whether it is with respect to divorce, child custody. There's also an issue with respect to guardianship, inheritance, succession, adoption. All of this would have to find its way into a separate act. There may be several difficulties for all of us. We'll have to unlearn what we have learned, and then new laws put in place. We'll have to again relearn all of that. I think we're all willing to do that because it's about time that we do it. How would we go about, and how has there been a difference with respect to other directive principles so far with respect to the Constitution? If you look at Article 21A, the courts, with respect, see, directive principles of state policy has always been in terms of guidelines with respect to socio-economic in nature. So with respect to education, with respect to environment, protection of the environment, with respect to protection of ancient monuments, all of this is in directive principles. So we could always say that it could remain in directive principles and we are not bound by it. How did we then find right to education as a fundamental right? Because there was an amendment. All of us found the necessity for a child to have access to education and free education, and therefore the Constitution provides for free education from the age of 6 to the age of 14. So all of them ensure that they get their education. This could not have been possible if we had left it in the directive principles. If you see between articles, say 36 to 51, which is all directive principles, 44 onwards, maybe 47, 48, all of them are with respect to protection of the environment. So we had Wildlife Protection Act come into place. We had protection of monuments. We had those acts come into place. So when we have been willing to transform all of this from directive principles to our fundamental rights, or by way of fresh legislations coming into place, I don't see the difficulty in us bringing the Uniform Civil Code. We could have deliberations on, recently there was a furor with respect to the hijab. The Karnataka High Court basically held that that was not essential religious practice, though the issue was with respect to whether they could wear the hijab in educational institutions or not, but it went on a larger issue which is pending before the Supreme Court. What we have to remember is, it is not anti-Muslim at all. If you realize society, we've always had Marwadi women covering their heads. We've always had, whether it's in terms of Manusmriti said a woman would always be under the shadow of her father and then her husband and then her son. It has progressed. We've had changes in all Hindu laws, starting from succession to even with respect to whether who has guardianship, who is a natural guardian. Even there has been an amendment. But we have to find changes in other religions too. Reason being, we cannot say that it is their essential religious practice. So the Supreme Court has always tried to define essential religious practice and see if these are just practices that you have adopted over a period of time, or whether if you removed this practice, would it affect your essential religious practices, or would it affect the core of your religion, which is also very similar to the Shabarimala matter. So when you look into all of that, it is very clear that it would not affect one's religion. So your right to practice your religion is not affected at all if one is given the freedom to live the life how they want to. And you'll have to ultimately start with Article 14. What does Article 14 talk about? It talks about equality. Where are you equal if you're prevented from doing certain things that men are allowed to do? 15 is against discrimination. Basically, there shall be no sense of discrimination, whether it's in terms of gender or whether it's in terms of religion. So if we can't have discrimination, then how can you say we will have changes in the majority of society, but we shall not have changes, and for a sect of society can continue to follow one practice? That cannot be allowed. Article 21 deals with personal liberty. Are you giving one woman that personal liberty or not is the question. No, we are not. Then we would have to bring about changes. There's a lot of debate that it affects Article 25. Your right to religion also comes with certain reasonable restrictions. Reasonable restrictions are, ultimately it says subject to either morality or subject to public order. And these reasonable restrictions are in terms of evolution of a society. So do you think that it is even feasible in this time, whether you could still follow certain practices? Come to ultimately, how are we going to gain? If we have a uniform civil code, how is one to gain? There's going to be gender parity. There's going to be equal status for everybody. There's going to be unity in diversity. There would be no difficulty in overcoming all of the problems that certain women face in society. We would also be able to overcome outdated laws, not in terms of just one sect of society. There are so many laws, even in Hindu society, which are outdated and which the courts have stepped in and changed. And then the legislator has stepped in by bringing in certain laws. With respect to tribals also, ultimately, the courts, if they're bringing a uniform civil code, all of them would come into that very sect. Men, of course, have always asked, if uniform civil code is there to bring about some kind of parity for women, where is the justification for where there is no parity for men? And there I would agree. With respect to Section 24 and 25 of, say, Hindu Marriage Act, you have the right to seek maintenance. And the right to seek maintenance has been as against either the husband or the wife. So in Hindu Marriage Act, there is the option for even a husband to seek maintenance from a wife. So there is parity there. But in the Criminal Procedure Code under Section 125, there is no provision for a man to seek maintenance. So let us look at a situation, say a man is not able to work, he's physically unable, or there is some mental problem, he's not able to work, then where does he go? Of course, if he's very old, he can go under the Senior Citizens Act, an excellent act that's come into force. But where does a man go if he's unable to work and there is nobody to provide for him? So there's some kind of balance would have to be brought in there, yes. So as we're trying to bring in parity, I think we should be looking into some of these small issues where even men get their rights. A lot of men have had issues with the Domestic Violence Act. Domestic Violence Act at one point of time was interpreted saying even if a man is a victim of domestic violence could always seek. Then the court said the language of the act is very clear. It's only meant for women and therefore men can't seek. And there have been men who have been victims of domestic violence. It's hard for some people to believe, but it is true. And therefore, these are areas where when the Uniform Civil Code comes up with a draft, none of us have even seen a draft so far. So when we do see a draft, I think when suggestions are called for, these are the kind of suggestions that we could put forth wherein changes could be brought forth in all of these areas. There have been talks with respect to the Uniform Civil Code followed in Goa. That was the old Portuguese Act which was being followed. It has had no problem so far. There have been several issues that need correction. So we can't say that's a perfect act, especially with respect to, Hindus where Brahmins were permitted entitled to a second marriage if the first marriage didn't give him a child, or rather a son, and therefore he was entitled to marry again. No, polygamy is not permitted. So, even if the Goan system permitted it, I don't think Hindu men are permitted anyway. So we can't say that it's only one sect of society that's going to be affected. Polygamy has never been entertained, and therefore it can't be allowed in one part of society, whether minority or majority. There's also the system in the UCC in Goa, wherein women are entitled to equal share of their husband's property. So the moment she's married, she's entitled to not just his personal property, she's entitled to even his ancestral properties in his HUF, all of it she's entitled to equally. But that also brings about a bit of a problem wherein men marry into a rich woman's household, wherein he would be entitled to all her ancestral rights, which then cost a bit of an issue. So there are several things that need to be ironed out. So it's not as if we could directly adopt the UCC from Goa and put it into place. Tweaking is required. And ultimately, all of us must, I don't know if I'm out of time and Justice Kumar has to speak. So I would just have to say, let's all put in a thought. Who is the one who is being affected all along? Have men been affected or women been affected? How have the corrective measures come into force? Have there any time there been corrective measures wherein we felt that women had the upper hand and therefore men required some kind of changes? It's never been so. All along, the changes that have been brought forth have been to support women who needed these changes to be brought forth. Who ultimately object to the UCC is what we need to say. Is it men? I'm not talking about religion. Is it men who object to it, or is it women who object to it? It's always been men. And we must not make it into a gender issue, since if so far, if there's been any progress in our society and changes in our system, it's been the men who fought for it, whether from pre-constitution days, whether it's with respect to social reformers, or whether it's our judges in the court. It's the men who also brought about these changes, and they're aware of the changes that we require in society. And if Uniform Civil Code needs to come through, then it would defeat the divisionist faction which remain in our society. And if we need a truly secular country, then we need a secular system and a secular law in place, which is uniform for all. Thank you so much.
Thank you very much, ma'am. As in, not only was it very comprehensive, it took us through a plethora of judgments. Your talk, also what we understood is that though women face the brunt of this faith-based lopsided personal law, they have the magnanimity to today say that they don't want reparations. They don't want for the historical wrongs that they faced, but just going forward, they want to see that they're given equal rights. Your point that Muslim women, if a large number of Muslim women were in the Constituent Assembly, maybe we would have a differently framed constitution, a different, maybe UCC would have been a reality, is something that I think every woman, every girl who is on this talk show today will take home. Thank you for giving us so much clarity and perspective on this issue. And to sort of fearlessly state the true facts on this topic. I have received many questions, so I request all speakers to stay on. There are many questions specifically on gender-based issues also. But before I go into these questions, I would request Justice N. Kumar to speak. And before that, I want to briefly introduce Justice N. Kumar. He is a heavyweight of sorts in the legal field. He's somebody that started from very humble beginnings, but has come so far and has contributed so much to the legal landscape of the nation that few words and few sentences that I have today are not sufficient. Every judgment that he has passed in his 16 year stint as a Karnataka High Court judge has not only strengthened the rights of women, but has also taken into consideration the poorest of poor, the persons who don't have the kind of legal support that somebody rich or somebody well off would have. So these are considerations that he taught the legal world, that this should be taken into consideration. And he has a long list of achievements. He was the Kannada Rajyotsava awardee for his contribution in the legal field. He was also the president of the Karnataka Judicial Academy, and he has been he has been training judges in a big manner. He is the executive chairman of the International Center for Alternative Dispute Resolution, Bangalore. He has also been an advisor for the Baswangudi Arbitration Center. So it's our honor and it's our great, I will say, fortune that you're here with us today. And I request you to sort of give us more perspective on the Uniform Civil Code.
Thank you.
Thank you, sir.
Good afternoon to all of you. This discussion on Uniform Civil Code, now we hear it all over the country. It started because the Prime Minister said it is time that we should think of Uniform Civil Code. But what is surprising is, even a draft of the Uniform Civil Code is not out. The Law Commission said, please give your suggestions. And suggestions are given. Today, 75 years after independence, people are opposing a legislation without knowing what that legislation is. It only shows how they are predetermined. They have made up their mind. Unfortunately, Kerala state legislature, even before knowing what is that mean, they have passed a resolution saying we are going to oppose it. That is the sorry state of affairs in this country, in particular about politicians and political parties. Now, I am glad that throughout the country, discussion is going on. And I am sure at the end of the day, people who are reasonable, liberal in their thinking, and their words would prevail, and the Uniform Civil Code would become a reality. Now, the two speakers earlier pointed out the Constitutional Assembly debates. A bitter debate took place. 5 Muslim members, tooth and nail, opposed this. They were successfully shifting it from fundamental rights to directive principle of state policy. Today, those who are opposing this have not said one word beyond what they have said 75 years back. And it should be said to the credit of Mr. Munshi, Dr. Ambedkar, Aladi Krishna, who are ably able to defend the draft, and it now finds a place in directive principles of state policy. I have been hearing this discussion throughout the country. But what I am surprised to see is nobody has gone into it in detail. Many of them are holding a brief for a Muslim community. Even the persons in the Muslim community also have not gone deep into it. During British regime, we had sati. By legislation, it was thrown out. Did any one person object to this? And the worst part of it is, the custom and usage in Islam was atrocious, inhuman. It is the Muslim community which represented to the British government to save them. And that is how the Muslim Act, that is Shariat Act, came into force. The Muslim Personal Law, Shariat Application Act 1937 came into force. So this act override the custom and usage in Islam. By law, Shariat was there. Nobody was following Shariat. Therefore, they requested a law to be made which will override custom and usage. In Islam, in Quran, there is no provision for a woman's divorce. A man can divorce the woman by saying talaq. What about the woman? Their condition was pitiable. Again, the community represented to the government of the day, that is the Britishers, and requested them to save them. Therefore, the dissolution of Muslim Marriage Act of 1939 came into force in 39. Today, you are talking about personal law. You are talking about Quran. Even before independence, these two laws were brought at the instance of the Muslim community to save them from these atrocities. Then we had independence in 1947. The framers of the Indian Constitution were conscious of the consequences of this partition, the brutality, the murders, and the violence. So, Pakistan became a separate country purely based on religion, whereas India did not believe in it. They wanted India to be a secular country. And they wanted this country to be one, because when we got independence, there were kings, about 500 odd kings. Some area was controlled by Britishers. All of them constituted the present Bharat. So the whole object of this Indian Constitution and its provisions are to see that this India is one country. How do you make it one country? Only if everybody in India are equal and the law applicable to them is the same, then you can have one country. Otherwise, you can't have one country. It is in that context, because in India we have the peculiarity of religions and personal law, the question was whether that could be touched. As I said, unanimously they were certain that uniform civil code is a necessity. Because of some disturbances in the assembly, it was shifted from fundamental rights to directive principle of state policy. Now, that provision is there for the last 73 years in the Constitution. 102 amendments were brought to the Indian Constitution as on today. The Parliament did not think of amending the provision. It means what? It is a necessity. Now, the question is, within 5 years from the date of coming into force of the Indian Constitution, Hindu Code was brought in. It did interfere with the personal law of the Hindus. The community accepted it. There were some provisions which are arbitrary. Time and again, amendments have been made. Today, as on today, the Hindu Code is perfect. It gives relief to both man and woman, and there is no discrimination. It is in conformity with Article 14 and 15 of the Indian Constitution. The ultimate goal of a constitutional democracy is equality, equal respect to the laws, and respect to the Constitution also. That is more important. Today, everybody is talking about Indian Constitution. More so the minorities. But if there is a provision which is not favorable to them, they don't want to respect it. This is not acceptable. Either you take the entire Constitution as a whole or reject it as a whole. You can't take provisions which are helpful to you and provisions which you think or against your interests and say, we will not respect. That means you have no respect for the Indian Constitution. If people have no respect for the Indian Constitution, the government, the judiciary, society need not respect them. Now, in these 75 years, several cases went to Supreme Court concerning Muslim women, Muslim law, Muslim personal law. Constitution benches have decided the cases. Now the law is well settled. All those persons who are today making hue and cry, either they are not aware of the settled legal position today in this country, or knowing it, they want to say we will not respect. That is not acceptable. The problem which today the Muslim community feels they are facing was faced by the Hindu community in 1946, before the Constitution. The Bombay state passed a legislation called Bombay Prevention of Hindu Bigamous Marriage Act of 1946. Polygamy was not prohibited among Hindus. If Muslim man can marry 4 women, there was no prohibition in Hindu law. He could also marry. This was sought to be prevented by this law in 1946, before independence. 2 persons were convicted. 2 persons on the basis of the act were acquitted. And the matter ultimately came to High Court. At that stage, we had a constitution. This enactment was challenged on the ground of violative of Article 14 and 15, and in particular, Article 13(1). The bench was presided by none other than Justice Chagla and Gajendra Khadkar. We have a very learned judgment in that case, which is now approved and followed by 2 constitution benches of the Supreme Court. That's the law today. What is the law? The argument was, among Muslims, they can marry 4 ladies. Among Hindus, only 2. There is discrimination, Article 14. That argument was negative by the bench, saying, don't compare Muslims and Hindus. This is a law which is meant to bring in social reform among Hindus. It is for the legislature to decide what is the type of reform to be done, which society is to be done. Merely because they did not bring in the same law to us Muslims, the law which is brought to reform Hindu society will not become bad. And they further said, Hindu society has grown, matured. This Muslim society is yet to mature. Probably in course of time, they will do it. That is how that act was upheld. Then they said, it's a personal law. That was negated by saying, marriage is a social institution. Succession to property is a social problem. It has nothing to do with religion. And therefore, the state has the power to legislate. Because all these arguments were built upon on Article 25, which makes this personal law a fundamental right. They said, yes, the personal law is a fundamental right, but if that personal law is against public order, morality, and health, then the state has the power to make law regulating or restricting the secular activity which may be associated with religious practice. So they have categorically held marriage, divorce, succession, though it falls within personal law, it is not an essential part or practice of religion. It is in that context In order to bring a social reform, the legislature has the power to make the law. So the right under Article 25 is not an absolute right. It is subjected to public order, morality, and health. This judgment, as I said, is upheld by two constitutional judgments of the Supreme Court, and this judgment is followed in all the judgments of the Supreme Court. So what I am trying to say is, today people are arguing freedom of speech is a fundamental right. Everybody has a right to interpret the Constitution in the manner they want. No problem. But under the Indian Constitution, the ultimate interpreter of this constitutional provision is the Supreme Court. You have fine English, you have fine vocabulary, and we see in the TV wonderful arguments of people. Absolutely no problem. But under the constitutional scheme, what the Supreme Court says is fine. And on this, the Supreme Court has already declared marriage, succession, divorce is not a religious matter. It is nothing to do with religious faith or religious belief. Since it is not falls within religious belief and religious faith, subclause 2 of Article 25 is attracted, and the legislature can pass a legislation regulating this. Now, the word essential practice has also been defined in several judgments, in particular, the latest judgment in Ayyappa's case. Now, let us say marrying 4 wives, is it an essential practice? They have said it is not an essential practice as far as Hindus is concerned. Let us see about Muslims. We had our late president, Abdul Kalam. He was not married at all. He was not married at all. Does it mean that he is not a Muslim? Today, 80 to 85% of the Muslims, in particular the educated Muslims, they all practice monogamy. They all practice monogamy. Are they not Muslims? So, therefore, if you apply the test of essential practice, this marrying for four women is not an essential practice. Yes, it is there in that community. It dates back to the days of 15th century. If you look into that, in the battle, men lost life. Only the women. Somebody had to take care of them. They said, all right, you can marry up to 4 and take care of them. That's all. And years have passed. And today, the population of men and women is not equal. You look at it from historical perspective, constitutional perspective, legal perspective, as the doctor was suggesting, biological perspective, saying you can marry 4 women and no law can be brought to prevent it is atrocious. Now we have several judgments of the Supreme Court on matrimonial matters. If a wife who is illegally wedded, after that, if a husband were to keep another lady, she has a right to leave him. It does not amount to desertion, and it amounts to cruelty. Now, if you want to have 4 wives, where are we? In 2013, will any society worth the name will accept this? And what is the position in other countries? In every country, they have accepted monogamy. You are not the original founders of this particular community. They are all converts. The original people are not having more than 1 wife. And the most advanced country is your country. There, only polygamy is accepted. So therefore, to say that uniform civil code is going to interfere with personal right of any particular community is unsustainable. In fact, Article 44 categorically states that the state shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. So it's a constitutional provision. There is a constitutional mandate to the state to enact this law. Unfortunately, for the last 73 years, the state has disobeyed this mandate in the constitution. If really they had respect, they should have respect. As Madam pointed out, it is not in one case. In 4 or 5 cases, Supreme Court has said, we are seeing the plight of Muslim women. We can give relief to that lady, but we have no power to make a law. And they have called upon the state to come out of the number and pass a law in conformity with Article 44. And they have also said, because the learned advocate represents state said, it is not that we can't make a law, there is no political will, political courage, because they have to face elections. So though Article 44 cannot be found fault with, the governments which have ruled this country for the last 73 years did not have the political will, political courage to enact this law. And it is not because of any other reasons. Now, for the first time, we saw there's a prime minister who just opened this topic, and now you see throughout the country, the agitation is going on. Very good. This is the essence of democracy. Let us hear everybody. Therefore, now the question is this law the need of the hour? Is it required? Everybody is simply repeating what either Jawaharlal Nehru said in 1956. He said, the community is not ready. That is what Justice Chagla said in 1954. The community is not ready. Community will be never ready. That is why a law is required. If you leave it to the community, who is that community? Has in that community, woman has a voice. Is woman allowed to come out of the house? Is woman allowed to agitate their rights? Forget about women. Men can't open their eyes, open their mouth. The society cannot keep quiet. Even the majority community cannot keep quiet. They have a duty in this country. We are interested in the country. The country should be united. The country should be one. Only when there is one law to the entire citizen of the country can prosper. And therefore, this argument that the community should make a representation, it will never happen in this country. And that's precisely what the Supreme Court has said, not what I am saying. Supreme Court has said, it is time that you take this step, first step, make the law. And let us see who is going to oppose. This law is meant for them, for their benefit. Who are the persons who can oppose this? For example, after independence, several laws were passed. Hindu Marriage Act, Hindu Succession Act, Adoption and Maintenance Act. Every law made inroads into the personal law of Hindus. Was there any revolt? Did anybody fight? Was any murders took place? When this amendment to Hindu Succession Act in 2005 was brought, conferring on daughters the co-passionate rights, again the people said there will be blunder, there will be bloodshed. I have not come across one case where one person was murdered because of that. The society accepts this. See, with my little experience, I can tell you, people are least bothered about the law. But if you make a law, take it from me, in every community, 50% of the people will simply obey it because there is a law. Because there was no law, I was enjoying. Today there is a law, we are law-abiding citizens. 50% will, without murmur, they will follow it. Another 25% will follow the law because of the penal consequences. They don't want to be on the wrong side. 50 plus 25. Another 15% will also follow law because they don't want to get into difficulties. Another 10%, they are incorrigible. Law or no law, they are not going to follow. Now, when a parliament or a state legislature wants to make a law, you can't keep this 10% or 5% mischievous fellows and say there will be trouble. They are troublemongers. They are troublemakers. The law is meant for the community, for the society. And if 90% are going to support this, why should anybody be afraid? And who are the persons who are coming on the TV screen and screaming? Do they really represent the persons to whom this law is required? I have not come across one Muslim woman coming and saying, no, we don't want UCC. If she says you want UCC, tomorrow her head will not be there. And what are we expected to do? Can we simply accept it? Can we say it is not our concern? That's why the Supreme Court has said time and again, it is the duty of the majority community to see that equality is maintained. If the country has to proceed, because we are interested in the country. If the country has to grow, if the country has to, as Aishwarya has mentioned, become Vishwaguru, if you have all these things, you can't think of it. You have to bow your head in shame. And we as a majority have to bow our head in shame that in this country such a thing is happening. Yes, tomorrow they are going to pass a uniform civil code. If there is any provision which violates their fundamental rights, they can file an objection to the draft. Assuming it is ignored and law is made, you can challenge it in the court of law. That's how your interest is taken care of. So therefore, we must be very clear in our mind about what is this personal law. Is marriage, divorce, succession forms part of essential practice? Is it something connected with faith? Is it something connected with religion? Time and again, Supreme Court has said, beyond doubt, it does not. It's purely a secular matter. If it is purely a secular matter, Article 14, Article 15, the benefit should go to everyone. You cannot think of peace in a society if a portion of the population suffer, live in misery. When we say constitution, constitutional rights, it is applicable to everyone. It can't be denied to any person. Even taking to the tribal people, what I am trying to say is when you make a law, 100% it is not going to benefit people. No law will reach 100%. The tribal population constitutes a very small. Always there could be exceptions. There could be a proviso. Even if it is not there, courts time and again have come to the rescue and no injustice is done. All this cannot be a ground for denying this country a common civil code, a uniform civil code. Today, every law is applicable throughout the country. Why not this law? What is the speciality about this? And if your argument is it is personal law, it's something personal to it, Supreme Court has time and again said it is nothing to do with religion. It is nothing to do with your faith. It is a social responsibility to the state. It is secular in nature, and the secular law should be equal to all. So when people start talking, we can't prevent them. In the end of the day, what the Supreme Court has said is the law, and the Supreme Court has already settled all these legal positions. And what is wanting is the political will. Because once in 5 years, you have to go to elections, policy of appeasement, vote bank politics. This is ruining the country. When you talk about a constitutional democracy, a leader, a real leader, should have the courage to do right things and then see what the people will do. You cannot go on doing wrong things, appeasing people, and actually it will be a mockery of a democracy. And that's precisely what is happening. Even after 73 years, the government is not making an endeavor to pass this universal civil code. Means it's a shame on our part. Therefore, the people who are talking will talk. But unless it is supported by proper evidence, proper reasoning, the only reasoning they are giving is the society has not reach the stage. Society, yesterday I was speaking from senior counsel, society should ask for it. What is the society you are talking about? What is the society you are talking about? Whom they should go to the Prime Minister's house and they must request it. Or to the Chief Minister's house and they request it. These are all wonderful arguments to be addressed in a Supreme Court in a constitutional matter. But what is the ground reality? Probably they are not aware of the ground reality. 80 to 85% of the Muslims are following monogamy. They can't afford to have a second wife. But who are the persons who are having 4 wives? They are living in slums. Even they are disputing regarding the age of the marriage. And when we are talking about a common civil code, what is that they are afraid of? The civil code will contain what is the age that should be of the boy and the girl. It should be common to all. There is no speciality about any religion. All are human beings. 2, all it will say is, if a boy wants to marry or a girl wants to, they should not have a spouse at the time of marriage. That's all. 3, it should not be within the prohibited relationship. That's all. And they should be mentally sound mind. That's all. What is the objection for this? I am not able to understand. Now, as far as the marriage is concerned, this is all. How the marriage is to be performed, who should perform the marriage, how the marriage should be performed, is purely a religious matter. Do whatever you want. Nobody is interfering. That is purely within your domain. All that they are saying is, what should be common to the whole country is the age of marriage, prohibited degrees of marriage. They should be of sound mind, and the person who is marrying should not have a spouse at the time of marriage. This is what the whole world is expecting. In fact, India is a signatory to all international covenants. The Article 16 of the Universal Declaration of Human Rights, Article 3 of the International Covenant on Civil and Political Rights, Article 10 of the International Covenant on Economic, Social and Cultural Rights. We are party to it. Whole world is party to it. And what they are doing is contrary to this. If you don't have respect for international covenant, if you have no respect for the Indian Constitution, why should we respect you? Are they against anybody? What is that personal right you are talking about? So the entire argument that the UCC will be contrary to personal right. In fact, the framers of the Constitution were very clear in their mind. After hearing the arguments in the Constituent Assembly, they specifically said in entry 5 of list 3 of schedule 7, marriage and divorce, infants and minors, adoption, wills, intestacy and succession, joint family and partition, all matters in respect of which parties in judicial proceedings were immediately before the commencement of this Constitution subject to their personal law. The word personal law is not there anywhere in the Constitution except in this entry. So they specifically said you can make the law. So therefore, well, if you don't want to look into these constitutional provisions, if you don't want to look into the judgments of the Supreme Court, if you want to look into the history, you can go on arguing anything. But once you see, I'm sure you have to think twice before opening your mouth. Therefore, the best thing is don't study, don't read, go on saying anything you want. It's in a public platform, nobody knows. Whoever has a very good expression, he will be acknowledged as the best speaker. It is not a question of giving prize. It's a question of law. It's a question of human beings. It's a question of society. That's why I said, on all these aspects, Supreme Court has, in unequivocal terms, laid down the law. And the law binds the whole country. And nobody is an exception. Of course, I have seen some people saying, we will not care for it. If you don't care for it, you have no place here. Either you obey the Constitution or don't obey the Constitution. You cannot say, I want Article 25, I want Article 14, 15, but I don't want Article 40. That is not totally acceptable. And as long as we allow these people to talk this nonsense, this continues. And as they said, women are bound to suffer. Maybe whether they are Hindus or Muslims, we say It's a male-dominated society. Fine, it was there. Today it is not the position. Today women are dominating it. Women are certainly dominating, and they should have an opportunity. And all this code will only give them an opportunity. The latest Chandrayana is because of women. The majority of them are women, and Indian women. Our country is in such a fashion. People are not prepared to accept hard reality. They were wearing saris. Flowers were there in their head. They were having, and it was a subject matter of criticism. The society has gone to the stage. Therefore, ignore these people. Who are these people who are making noise? They have no respect for the society. They have no respect for the human being. They have no respect for the country. All jokers. So when we are thinking of a law to protect the interest of everyone in this country and to make the country strong, they have a right to express their opinion by all means. As I said, in the Constituent Assembly, powerful arguments were put forth, and equally they were met, and ultimately it was overruled and the law has been made. I did not see one extra word being used by the present day people. At least they were learned, not these people. So therefore, it is an objection for the sake of objection. In fact, we have inherited this parliamentary democracy. What the essence of parliamentary democracy is, as an opposition party, you should not accept what the ruling party says. That's all. When this party becomes a ruling party, those people who are trying to do this, they will also oppose it. That is parliamentary democracy. So therefore, too much weight should not be given to this opposition. We have a written constitution. That constitution has been interpreted by the Supreme Court, and that interpretation is accepted, acted upon in many judgments. I don't think any more thing. The parliament has the competence to pass law. The constitution provides for passing of the law. In fact, it's a mandate. It's a constitutional mandate. That mandate has been disobeyed for the last 73 years by successive governments, without exception. If the government today has opened its eyes and wants to respect that mandate, and the hue and cry we are seeing it, well, give them an opportunity. Essence is dissent is the essence of democracy. That's all. You need not worry about it. The country is behind this law, and if the law is made, I'm sure as law-abiding citizens of this country, to whichever community he belongs, to whichever religion belongs, they will obey the law, because the law is good for them, good for the society, good for the country, and good for the mankind, man or womankind. Already. When I say mankind, man includes women. So therefore, I'm glad that such a opportunity is given for this discussion. If we don't raise our voice, they said the democracy has suffered not because of bad people, it is because good people are not opening their mouth. So thank you for giving me an opportunity to open my mouth and make my views. How far it carries weight, a different thing. Now we can say ourselves, I did not keep it. When an opportunity came, I opened my mouth, and to the best of my ability, I have put forth and whatever I said is not from mine. It's based on the Indian Constitution, based on the judgment of the Supreme Court, based on the legislature done prior to the Indian Constitution. It's purely based on facts, based on records. Thank you.
Thank you. Thank you, sir. Thank you, sir, for reminding each one of us and the government that it's a constitutional duty and a mandate for the government to have the UCC. And as you said, it's all of our collective duty to stand with the Uniform Civil Code to ensure that every girl child, every child has equal opportunities and equal rights. Now, I just want to set the discussion open for questions. The first question that we have received is from the director of IIT Gandhinagar. Professor Rajat Moonaji is with us, and he wants to ask a question, sir. Please go ahead, Rajat Moonaji.
Yeah, so my question is basically, I mean, we know UCC draft is not known, and what we are assuming is that UCC is going to handle things like marriages, codes for marriages, codes for divorces, codes for inheritance, codes for successions, code for such kind of things. This is what we can possibly assume that and rightly assume that it is going to be covered. But then when we actually talk of uniform civil code, there are many other aspects that one has to look at. I mean, like, for example, triple talaq was a lopsided, one-sided practice. If it was equally available to women also to be able to say that, then probably there was no problem. And this was the same practice that could have been adopted. So my question is that there are many other issues that actually prevail. Like, for example, the way people dispose their dead bodies in the, this is highly religious. The way certain rituals are carried out, for example, during birth and post-birth, they are highly religious. And many of them are not scientific. So the question is that shouldn't the UCC also address these issues? Shouldn't the UCC also address issues related to, in general, for example, civil order? I mean, noise, the way commemoration can happen, the way, various functions, religious functions can happen in public and all that. Shouldn't the law be also addressing some of those things?
Let the civil code draft be out. We'll find out what are the areas covered. And secondly, again, I said, for example, how dead body is to be disposed of, how obsequious ceremonies is to be done, who should do it. Probably it's a matter of religion. So some freedom, because that doesn't affect the others, should be given. But anyhow, once the draft comes, always you can make amendments to it. When a law is passed, that is not final. If there is something is wanting, therefore the law provides for amendments. You can add something. But we don't have the child itself. First, let the draft come out, let some law be there, then we can add all those things. At this stage, if you go on meticulously maintain this, the draft will never come at all. Broadly, let us draft dealing with marriage, divorce, succession, adoption, maintenance, child care, let it come, which is equal to, it is applicable to the whole country. And these minute details can be worked out later.
To, in fact, add over there, he mentioned that if triple talaq was available to the woman also, even if it is available to the woman, we have to see whether it is a fair practice or not. So it is not as if assuming if polygamy was available to women and they could marry 4 husbands, would that be permissible? No. So it isn't as if it's just a problem because it was available only to men. It will still be a problem if it is available to women too. With respect to disposing of dead bodies, there's a Parsi Tower of Silence here in Bangalore. It was in the outskirts of Bangalore all along. Right now, it's in the middle of 2 huge properties, and therefore that's not being used. So everywhere, whether it's society has progressed or evolution or real estate, the point is ultimately there are other permissive ways which find their way automatically into society. So these are things that we will evolve into.
Thank you.
We have another question from a student from KLE Law College, Bangalore, by Mr. Anmol. If so many people are now saying UCC cannot be implemented without consultation of all communities, isn't it time that we review the Hindu HUC also, which Nehruji did in 1956 without taking into account considerations from the Hindu community? This is a question for both Justice N. Kumar and Lakshmy Iyengar.
If that consultation is the requirement, the Law Commission has said, give your opinion. Consultation is done, that's all.
Yeah.
The views of the society is called for. The view of society is given. They are looking into it. There should be more than. This is what I said. This is what has been repeated for the last 70 years. You should look at the practical difficulties. In a country of 140 crores, how many people will be participate? To whom they should go and say, and what they should say. These are all with great respect to our law students. Very good. That's the line in which they are thinking. But they should also ground level. That's why the Law Commission said, if anybody has got anything to say, that's the consult. That's the more than.
There's a difference between consultation and consent. It doesn't ask for consent. It says consult. And therefore, I don't think there's consent required. You take a broad consensus from people and then determine what is correct. And with respect to the second half of it, no, you cannot undo what has already been done in the Constitution and the Constituent Assembly. All that is final. So no, you can't undo that.
Thank you. I think that must have answered his question. Another question from a chartered accountant, Sheshgiri Kulkarni. If the UCC is passed, can it really be implemented? Is his question.
What is the question?
If the UCC is passed, will it really be implemented?
Certainly. When it becomes the law, it will be implemented. It confers rights on people, and people, if the right is affected, they approach the court. That's the effect of a UCC. Once it becomes a law and it is given into operation, then the courts are there to enforce it. Aggrieved persons can approach the court.
I
Then
think
act comes into force, and ultimately the courts will have to follow it. So it's just automatic.
yeah. And the judiciary has already implemented it without there being a UCC. It's
True.
already upheld the rights.
True.
That is what Supreme Court has done. Here, if that is done, you are court at the lowest level throughout the country. They will implement.
Yeah.
And to add to that, in fact, the lowest courts, for example, even the family courts have stepped in, even with respect to, for example, custody of a child in a certain religious practice. They say that after 7 years of age, the child goes to the father, a male child. And if it's a female child, it remains up to 17 years with the mother. But the courts have stepped in. They say the interest of the child is of paramount importance. So they decide, and even if the child is older than 7 years and it's a male child, they still give it to the mother because they think that the mother is a better guardian. So the courts have always stepped in a different format and still overcome personal laws.
There's another question by Vinod Sangram, who is a student of the Krishi Scientific University. The present judiciary is in favor of non-Hindus. Does UCC make this better?
Sorry, the present judiciary is in favor of?
Non-Hindus.
That is his impression, that's all.
That's a matter of perspective, because you think that's what it is. When each judgment comes out, you think that there's a bias. Ultimately, it's humans who are sitting there as judges. They try to be as unbiased as possible, but then that's the impression that's given that we cannot help.
Another question from Mr. Venkatesh Kikkeri Srinivas. Going by the conduct, tenor, and tone of the present government, it is the Hindus who will lose much more if UCC is implemented. Hindus have already lost many of their dharmic codes through the implementation of the Hindu Code Bill. How much more can we cede ground? Why reform a dharma? Why is UCC needed for Bharat?
So he is imagining that by UCC, Hindus are going to be affected further, which I am not able to understand. We have come to the end. There is nothing to lose. The joint family system is broken. Co-partitionary concept is thrown out, and certainly marriage laws are in conformity with the requirement of today's societies. Even among Hindus, there was no divorce. So Act gives a first chance for a divorce. Among Muslims also, there was no law. In 39, in fact, they brought the law earlier to us. So therefore, because that's what I've been hearing, and I don't know what more they can take away from Hindus. They have taken away everything. And in that way, in the process, you have not been affected in any way. It's a question of adjusting. So.
And his understanding itself is incorrect. That a lot have been taken away. What Justice Kumar is saying is that there's been a lot of compromise by the Hindus all along. But in respect of being taken away, ultimately, it has only been set right. The rights of women in inheritance, nothing has been taken away. If some right of yours has been taken away, it was incorrect in the first place, and therefore it was set right. So if you think that by UCC some more corrections are to come, I don't think. In view of the fact that already all the corrections are already in place, and if you think more corrections are going to come in place, it's probably to only set right an imbalance. So there's nothing wrong there.
Let me tell that youngster, rely on Manusmriti. Manu has said, keep your women folk happy, you will be more prosperous. And therefore, Hindus are more prosperous today because we have kept our women folk free.
Thank you, sir. And just to add to this, I think the speakers would agree that our religion is much bigger than these aspects. Because for us, religion is more about spirituality and about sort of reaching moksha. So for us, these small aspects are not as important.
In this context, let me tell you,
Yes, sir.
Manusmriti, Yajnavalkya Smriti maintained equality. It is subsequently somewhere we lost that equality. And today simply they are blaming Manusmriti. They are simply blaming You read the Smriti.
I think
there is no
every
discrimination between man and woman in that. It is only subsequently the persons who interpreted it. They have ruined it. Now today also we have many judgments Supreme Court, which does not really interpret the Constitution properly. So
Well,
that's a system. So over a period of time, it has to be corrected. Now we are correcting the system, and today's interpretation and the today law is in conformity with what Manusmriti has said it and what Yajnavalkya Smriti has said.
It's
We have
also
respect
with
to them
respect to
by
going
this.
ahead with times. If Manusmriti or Yajnavalkya came, of course, there's a difference. Yajnavalkya, in fact, separated law and separated personal practices, whereas Manusmriti was a combination of everything. But you have to look at it at which point of time it came about. And you have to talk about evolution. So what we need to take from that is with respect to how it is applicable in present times. For example, we are far ahead in terms of law and understanding of law in comparison to certain developed countries. If you saw one of our ladies from Karnataka suffered over there, she was not allowed to abort her child despite the fact that the medical termination had to be done. She could not survive, and they didn't allow her to do it. They did not even allow her to travel to India, because they knew she'd come here and do it. So she was held hostage there. She lost her life only because they had some ridiculous practices that they're still following. But nobody seems to say anything about that. They are called developed countries, whereas we as a developed, they call us developing country, they call us third world country. But believe me, our laws are way ahead in place. Even in terms of animal rights, if you look, what Menka Gandhi has done, what several other people have done to bring about the laws of animals in place. Abroad, you don't have that. 1 month you keep them in a pound and then you kill them. Here we have such beautiful laws in place wherein you have to sterilize them, put them back on the roads. So in every form, we're way ahead. This is what is left. UCC is all that's left.
Manusmriti says, after the death of the father and the mother, the children will share the property equally. He did not say sons. Children will share the property equally. When? After the death of father and mother. Is it the law today? I think that was the most advanced law. After the death of the father, mother gets it. After both of them have gone, children will take it equally. And today law is that children are taking it equally. That's all. So we have restored Manusmriti by these amendments.
No, thank you very much, speakers. I think this has given all the students who joined today, all practicing young lawyers, so much perspective on this issue. And we've all productively spent this weekend, and that itself is great for the present generation. To give closing remarks and to thank the speakers, I would like to invite Professor P.V. Krishnabhatji, who is the Chancellor of the Orissa University, the former National President of Akhila Bharatiya Vidyarthi Parishad, and also Guru of Shri Anand Kumarji. Professor, please take over, sir.
Respected speakers of the day, and the very efficient convener of the program, Aishwarya ji, and the other participants in this very important and very timely discussion that is taking place on Uniform Civil Code. Legal luminaries in this subject have spoken, and I am not a person having much knowledge about law or jurisprudence or any of these subjects, and therefore I do not venture to make any comment on these issues. Only a few general observations that can be made. The Constitution provides for a uniform civil code with the directive principles of state policy. Directive principles, when they were visualized, I don't think they were there only for the purpose of some, say, a formality to be in the Constitution. When they were framed, the thinking was that in course of time they will have to be implemented. And therefore, now when the government is taking some steps to implement those policies, I do not know how some people find find something wrong in it and try to create a hue and cry about it. That is meant to be implemented. And in the wisdom of the members of the Constituent Assembly, they thought that in course of time, the government will have to take steps to implement these things in the interest of social justice, in the interest of well-being of all the people. And that is how it is being done. In a democratic system, I think any particular community cannot claim a separated system in the name of personal laws. I remember the struggle made by Shyam Mukherjee for the integration of Kashmir. The three slogans he raised at that time was, Ek desh mein do pradhan, no nishan, no vidhan, nahi hoga, nahi hoga, nahi hoga. So no do vidhan, when he said two systems of law cannot exist in a country. There will have to be a common code, common system of law, and equal justice will have to be provided to every individual. That is the essence of democracy. And the question of uniform civil code also, it had come into discussion at that point of time. And most of the members, they were also in favor of it, but it could not be made a part of the Constitution, as Justice Kumar has already pointed out, because of the pressure of some individuals, some persons there in the Constituent Assembly. Now I think after such a long time, changes in the Constitution, that is essential and it is a natural thing to be done. So whenever there is some development in the country, according to the situation, according to the needs of the time, necessary changes will have to be made. Even the Manusmriti says this. There is a shloka in the Manusmriti which says, Parityajet arthakamo yasam dharma vivarjito dharmancha pyasukho darkam loka vikrishtam evacha. Parityajet arthakamo yasam dharma vivarjito. So artha and kama, which are repugnant to dharma, they must be rejected. They must be disallowed. At the same time, even dharma, if it is a loka vikrishta, if it is against the common perception, common view of the people, common interest of the people, it also will have to be changed. So Manusmriti never said that this is the last word and this sentence or this injunction will have to be followed forever. So it also permitted changes in the system of law, and therefore, in accordance with the principles of justice, now we have adopted a constitution which declares the sacred values of justice, equality, and fraternity. In accordance with that, changes will have to be brought about in every sphere, and in the sphere of justice and legality also, there needs to be changes brought about. So, in the ancient times also, in our system of law, so far as inheritance is concerned, we all know there are luminaries are there, and therefore I need not mention all these things to them. There were two systems of inheritance, Mitachara and Dayabhaga. And there were several systems because we had a common system code of law that was provided by various Smritis. Smritis also underwent changes. Manusmriti is said to be the first Smriti, but later on there were several Smritis. The legal luminaries, the Smritikaras, they brought about certain changes in according to the needs of the time and or in accordance with the demands of the time. So changes were made. There are certain new things in Yagyavaka Smriti compared to Manusmriti. There are changes in the other Smritis also. So in this way, we find that changes have been taking place even in the past. And the various codes of conduct, codes of law that existed at the time of independence, they were all sought to be summarized together and brought about in the provisions of the Constitution. Therefore, to claim that a certain community has got a right to have its own system of law apart from the Constitution, it is repugnant to the system of democracy and it cannot be accepted. And it is the right time that changes are brought about and a uniform system of law is brought about for the country. And if the country is one, the system of law also should be one. And just as I mentioned in the beginning, there should not be do vidhan in terms of Kashmir. Similarly, in the matters of law and jurisprudence also, there cannot be dual systems. Of course, one thing is certain, Justice Kumar has already pointed out to that. Ours is a country with vast differences, varieties. There are various different kinds of customs. For example, the tribes of Assam, Nagas, and Mizos, they have got their own traditional practices. And somehow these traditional practices will have to be accommodated in the new system. Some provisions can be made. Similarly, with regard to certain things, for example, if there is a common rule regarding monogamy or any religious marital practices, how the marriages are conducted, it may be left to the different communities. Naturally, it will have to be done. So in this way, providing for these differences, a common system of law is the need of the hour, and the government has taken the right steps in this direction. And there are some certain voices of dissent, and the people who think in terms of the larger interest of the country, the unity of the country, it is time for them to come together and assert themselves and support the move that is expected to be taken up by the government. Of course, government has not yet made any declaration in this behalf that it is going to bring about uniform civil code, but discussion is going on. And I think an atmosphere will have to be created in the whole country that the country needs one common system of law. And if government makes any move in this direction, the people will be behind it. People will definitely support it. And I think it has been a very useful discussion. Eminent scholars have spoken. And I would not belong to that category of eminent scholars, and therefore I do not want to make a very long speech. And I congratulate Tejaswini ji for taking up such issues and bringing up and creating occasion for such important national matters to be discussed and brought to the notice of the public at large. Once again, I thank all the participants and all the eminent scholars who have participated in this seminar. Thank you, Cheta.
Thank you very much, sir.
Sure, yeah, sorry.
Thank you, sir. Thank you, sir. I request the speakers can log out if they want. Thank you, everybody. I request all the audience to fill their feedback on this feedback form that's being displayed on the screen. And we will come out with new such dialogues. Further, I request Sujit ji after this to give us an internal vote of thanks for all the team members who have worked to make this a success. there have been a lot of people behind this event. I request Sujit ji, an alumni of IIT Kanpur, to give a vote of thanks. Purna ji, I request Purna ji to unmute Sujit ji.
Okay, thanks, Aishwarya. Thanks. Namaste to all our participants. Before I formally deliver this vote of thanks, I would like to say that session was really amazing. Amazing. We spent more than 2 hours, and it's almost like without blinking our eyes. All our speakers were great, accomplished in their areas. So delivering great lecture is natural for them. However, I think important in this session was the way they brought this session to understand a common person like us can understand. And each and every our speakers, we were they were able to deliver the session which all of us can understand. Indeed, it was a great session from our speakers. So, in fact, I would also like to thank our speakers, although they are left this, but I would like to thank our speakers as, say, for example, Sri N. Kumar ji. True to the topic was like ground reality beyond the noise. And in fact, he was able to bring what is the ground reality? How is this ground reality in terms of social evolutions are happening and in starting from pre-independence era. And then he was coming to the noise. What is the noise behind this? So, and very rightly he mentioned is like predetermined noises. Noises are from the person who are very much disconnected, don't have respect to the society. Without legislation, they are making the noise. So, and Madam Lakshmy Iyengar ji, very nicely, she put the way forward. How is this way forward moving? How is this UCC is not just bringing equality in the religion. I think she was trying to give a fair, there should be fair among the genders. Mostly it is women who are suffering. So how is that it is becoming fairness to the society? And I think very rightly she mentioned, if our constitutional body would have been women, especially from Muslims, our situation would have been different today. And at the same time, she was giving fair to men, credit to men also. The way was what men did. And of course, I will say Anand Ranganathan ji, very nicely he put the how is that the caring for the future of the society. And I think that is one of the theme of our Pratisthana is where Anna, Akshara and Arogya. And this theme is based on how is that we build the future generation. And I think there also Anand Ranganathan ji was bringing how is that UCC is good for our future generation. Now, coming to our sincere thanks to Anand Kumar Pratishthan for providing this platform to address socially relevant topics which impacts millions of people of this country and abroad. Not only brings the platform where we all share our thoughts, but I think this platform which takes those thoughts to the common man, that is the most important, and closer to the policymakers' other sides. In this regard, I would like to thank Krishna Bhatt sir for giving us continuous guidance, which shows us the path, how is that we move forward. Sir, thank you so much for this thing. Our sincere thanks to Srimati Tejaswini ji. Become the anchor, always standing. Whenever we need, she is there. And whatever we have today, this session is all shaped by her. She was always behind how is that we make such sessions very, very successful. How is that to bring the topics? How is that to bring the speakers? All credit to Madam Tejaswini ji, and thanks to her, basically. Our sincere thanks to all participants, all audiences from the different various part of the society, being from students, being from teacher, being from other social sectors. I sincerely appreciate their time they spent with us patiently, so patiently. And our sincere thanks for participating in this very interactively. We could not take all the questions, but at least their participation is very, very important here. So I sincerely thanks them. It's like, again, I repeat, it's more than 2 hours and they are here. A sincere thanks to them. So to all our participants, we conduct this session on regular basis. So my sincere request is keep watching for our next session. We'll be coming with such interesting topics again. So keep watching for our next session. This session would not be possible without our host, Aishwarya. Aishwarya ji, wonderful job. The way you have hosted the session is amazing. The way thoughtfulness you brought in the session is really, really impressive indeed. Thank you so much. I'd like to thank Vijeta, who is behind the scene today, although I don't see her, but she is the person who continuously put effort for last more than a month, bringing all the components together and making it happen. Our sincere thanks to all our, once again, to our speakers, our audience, and all our other volunteers of all AKP who helped us to make this session successful. Last but not least, I would like to thank all the participants, speakers, and any other person who supported us directly or indirectly. So sincere thanks to all of you. And with the permission of Krishna Bhatt sir and Tejashni madam, we can conclude the session and requesting all participants to please join our next session.
Thank you.
Thank you.
Thank you, sir. Thank you very much.
Thank you.
Once again, as Sujit sir said, we request all of you to join for our next session. Thank you very much. Thank you.